Welcome to Wings of Fire Dreams. Today we are going to see the day 4 topics of TNPSC preparation. This topic is official languages and emergency provision. We have took the content from 10th and 12th standard book. Official language. Part 17 of the Constitution deals with the official language in Articles 343 to 351. Initially, the Constitution recognized 14 regional languages which were included in the 8th schedule. At present, 22 languages are recognized: Assamese, Bengali, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Malayalam, Manipuri, Marathi, Nepali, Oriya, Punjabi, Sanskrit, Sindhi, Tamil, Telugu, Urdu, Bodo, Santali, Maithili and Dogri. Of these languages, 14 were initially included in the Constitution. The Sindhi language was added by the 21st Amendment Act of 1967. Konkani, Manipuri and Nepali were included by the 71st Amendment Act of 1992. Bodo, Dogri, Maithili and Santali were added by the 92nd Amendment Act of 2003, which came into force in 2004. In 2004, the Government of India decided to create new category of languages called classical languages. So far, 6 languages are granted the classical language status, namely Tamil, Sanskrit, Telugu, Kannada, Malayalam and Odia. Emergency provisions. National emergency. Article 352. The President under Article 352 can declare emergency if he is satisfied that India's security is threatened due to war, external aggression or armed rebellion, or if there is an imminent danger or threat. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. When a national emergency is declared on the ground of armed rebellion, it is known as internal emergency. The type of internal emergency has been declared 3 times so far, in 1962, 1971 and 1975. State emergency. Article 356. Under Article 356, the President can declare an emergency in a state if the Governor reports that a situation has arisen under which the government of a state cannot be carried on in accordance with the provisions of the Constitution. The continuance of such an emergency beyond 1 year is possible only if emergency under Article 352 are in operation, or the Election Commission certifies that there were difficulties in holding assembly elections. Maximum duration of the emergency can be 3 years. The state is governed by the governor on behalf of the president. For the first time, the president's rule was imposed in Punjab in 1951. Financial emergency. Article 360. The Article 360 authorizes the president to declare financial emergency if he is satisfied that the financial stability or credit of India or any of its part is in danger. In this type of emergency, salaries and allowances of any class of persons serving state or union, including judges of the Supreme Court and High Court, can be reduced by an order of the President. This type of emergency has not been declared in India so far. Amendment of the Constitution. The term amendment denotes change, improvement and modification. Article 368 of the Constitution in Part 20 deals with the powers of Parliament to amend the Constitution and its procedure. Procedure of amendment. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either house of the Parliament, and when the bill is passed in each house by a majority of the total membership of that house and by a majority of not less than 2/3 of the members of that house present and voting. It shall be presented to the President, who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the terms of the bill. The Constitution amendment can be brought about only by the Parliament. State legislatures cannot initiate for any amendment to the Constitution. Types of amendments. Article 368 provides for 3 ways of amendments: amendment by simple majority of the Parliament, amendment by special majority of the Parliament, amendment by special majority of the Parliament and the ratification of half of the state legislatures. 42nd Amendment of the Constitution is known as the Mini Constitution. Amendments by simple majority of the Parliament. According to Article 368, a number of provisions in the Constitution can be amended by a simple majority of the 2 houses of the Parliament. These provisions include admission or establishment of new states, formation of new states, and alteration of areas, boundaries, or names of existing states. Abolition or creation of legislative assemblies in states. Second schedule, emoluments, allowances, privileges, and so on of the president, governors, speakers, judges, etc. Quorum in parliament, salaries and allowances of the members of the parliament, rules of procedure in parliament, privileges of the parliament, use of English language in parliament, number of judges in Supreme Court, conferment more jurisdiction on the Supreme Court, use of official languages, citizenship, elections to parliament, delimitation of constituencies, union territories, fifth schedule, administration of scheduled areas and scheduled tribes, sixth schedule, administration of tribal areas. All these can be amended by simple majority of the parliament. Amendments by special majority of parliament. The majority of the provisions in the constitution need to be amended by a special majority of the parliament. That is, a majority more than 50% of the total membership of each house and a major of two-thirds of the members of each house present and voting. The expression total membership of the house is irrespective of fact whether there are vacancies or absentees. The special majority is required only for voting at the third staging of the bill. The constitution clauses which can't be amended in this way include fundamental rights, directive principles of state policy, and all other provisions which are not covered by the first and third categories. Amendments by special majority of parliament and consent of states. The basic structure of the constitution which are related to the federal structure of the polity can be amended by a special majority of the parliament and also with the consent of half of the state legislatures by simple majority. There is no time limit within which the states should give their consent to the bill. The following provisions can be amended in this way. Election of the president and its panel, extent of the executive power of the union and the states, Supreme Court and High Court, distribution of legislative powers between the union and states, any of the list in the 7th schedule, representation of states in parliament, power of parliament to amend the constitution and its procedures. Constitutional Reform Commissions. The National Commission to review the working of the Constitution was set up by a resolution of the Government of India in 2000, headed by M. N. Venkatacharya. In April 2007, a three-member commission headed by the former Chief Justice of India M. M. Punchi was set up by the government to take a fresh look at relative roles and responsibilities of various levels of government and their interrelations. Thank you for watching this.